Just as a reminder, if you have any questions, feel free to type it in the chat feature in the bottom. At the end, I'll try to unmute everybody and you can ask oral questions if you want to. It just it makes things go a little bit easier if we do that. But if you have something along the way, type it in the chat feature. That way I could come back to it later, or maybe if I see it right then and there, stop. But today we're going to be talking about reviewing your estate plan. So let me get my windows going here. Share my screen. Thank you for bearing with me. So, today's, estate planning, very important part. And, one thing that we always try to touch on, usually in the fourth quarter, under the financial planning section, when we do education amongst our various, 401ks that we work with, but extremely important. And, not something that everybody likes to think about. And I've had experiences that are very easy to get people to come into this space and really know that they should do it. And I've had others of which I've had to kind of pull through, and I still have that. And it's totally understandable. None of us like to think about our mortality in this world, but it's inevitable. And so that's why I titled this. A lot of you already have wills and some things like that. That's why I titled it, Review Your Estate Plan or Get One. And if you don't have one, we're going to talk to you today about quite a few reasons of why you should, and kind of give you the high level points of the basic things that you'll need, maybe introduce you to a couple of other things. Unfortunately, I did have an attorney, a good friend of mine, Lyle McQuinn, was going to join us, and he had an emergency court Zoom call that came up at the last second and let me know yesterday that he was not going to be able to attend. So it's unfortunate, because if Lyle were with us, I would have just sat back and let him talk, because he is he's very good at what he does, and I'm really probably the best, one of the best anyway that I've seen at explaining things at such a simple level. So apologize that he's not here for that. I was really hoping to get his assistance and expertise, but we'll get through it. And I've learned a lot from, honestly, just listening and mirroring Lyle and a couple of our other attorneys that we work with on a regular basis. So really, estate planning, the first question is why. And all of us work hard, and all of us really, try to lead our lives in which we can control what we can control. We want to, in our family, we try to raise our kids to be good Christian people, to be good people. And so we, it's no different in, in how you all. So really the biggest reason why is to have a big say in what happens, not only for stuff that you have built and to leave to your loved ones, but possibly even who should not have certain assets. And that's not from like a mean, angry type thing. It might be from a self-protection. Estate planning sets up a structure which minimizes conflicts between family members and allows a more smooth transition of assets. And kind of the bonus of it is, if when it's done right, it forces you to take an inventory of everything you have. And a lot of you all are very successful and maybe have invested in different things well outside of your businesses and where you work. And sometimes some of those things, honestly, just get forgot to be told to other loved ones. It's very strange talking about finance with loved ones, and this helps get that smooth transition. So if you don't have an estate plan, what happens? Well, probate and a probate court judge, and we'll talk about what probate is and more specifics in a minute, but the probate court judge gets really a monster say in all kinds of things and how your assets are distributed, including the possibility if you pass away or you and your spouse pass away with minor children, including the guardianship of your kids. So, for me, it's very important that we pick, all of my family loves my kids, but they, some would be better than others at managing them in, between now and through adulthood. And it's not picking favoritism. Sometimes it's just an easier fit. And so, if you don't have one, biggest consideration is your kids, if they're still in the house and all of that. The second one is, people you don't know or will be in charge of how your assets are distributed. That's the court, legislatures, and those kind of things. And in some cases, some of your assets can end up to people you might not expect them to. So really, again, it comes down for you to have a say, and for you to kind of spell out your wishes in a more clear, concise manner. So what does an estate plan include? So these on the list on here, I'm not going to read every single one of them, but Lyle does a great job of breaking estate planning down into two kind of phases. We have what he calls above ground planning and below the ground planning. So estate planning is not just for when you die. It could be things in preparation up to it, including maybe losing mental capacity. So in some cases, we'll talk about it in a second, a durable or general power of attorney, healthcare power of attorney, will, maybe a revocable trust would be something that would benefit you and your families. We'll talk a little bit about trust, get my feelings in on that. Maybe it's a statement of disposition, or like an asset list, of tangible personal property. Some of it might involve retitling of assets prior to death, or retitling those assets for expectation of passing away. Beneficiary designations. Everybody on this call has had an exposure of being able to do that. And at its basic terms, that's part of estate planning, very important one. And we'll talk just a quick second about that too, and I'll give you my 2 cents. Guardianship designations, and then of course, the life insurance or irrevocable trust are big parts of it too. So before we get into it, we'll talk a little bit about the first couple things, which are above ground planning. So a general power of attorney. So this document handles your financial matters. And when does it become effective? So it's defined in a myriad of ways that estate attorneys understand triggers that this might be needed. It could be immediately upon incapacity, or when activated by writing from the person who is giving the attorney to someone else, the power to someone else. This basically provides someone that can rule over financial matters or any kind of thing as an attorney, in fact, for said person. And it's important to have one for everybody. And, on here it says that for assets not owned by a revocable trust, but I think in any case it is. I want to give you a quick story that I came across personally with a client, to give you an understanding of how important it is, and how just neglecting power of attorneys and wills can have a big effect. Now, this one has a happy ending, or I probably wouldn't tell it, a happier ending, I should say. But I have a client that I've had for years, and he's been retired for about 7 years now, 7 years. And I had been on him, he's one of my older clients actually, and I'd been on him prior to retirement about getting, he in my opinion qualified for trust for a lot of reasons. He was a very successful person and had managed to save quite a bit of money. He kind of had his own business. He ended up, transitioning and selling that business toward the end. And he just did not want to think about that next step. And probably 2 years before really I knew that it was going to be inevitable, he was going to retire as he was transitioning his business to his partner. I was really honest, like, you've got to get this done. It's too important. You have a substantial amount of money. So we actually started the process about, I don't know, 3-4 months prior to retirement. It took him that long to kind of not necessarily warm up, just to act on what I'd been pushing him for almost 2 years. And so we had met with the attorney. They had come up with solutions, and the paperwork was in process, but not executed. In the meantime, my client had a major health event. He suffered a near catastrophic, and at the time it was catastrophic, but a near fatal, I should say, stroke. All that the client's wife had at that point in time was the amount of money in their joint checking account. The client's wife was a stay-at-home mom. She had kept the kids for years. She was a volunteer, very big in the American Heart Association, American Cancer Association, raised money for philanthropies. And then this happened, and my client was non-communicative, meaning that client could not speak and could not move, with any great intent. And the long-term prognosis was actually better than what the short-term felt. But they knew they needed to get him some advanced therapy in order to speed up the process. They thought it was going to be about 1.5 to 2 months before he would have to learn to speak again, and those kind of things. It actually took closer to 3 by the time he had left that high-intensity rehab, which they needed extra money for. So in order for my client, the client's wife called me up, they needed money. And as much as I wanted to be able to just press like a button and send money on his behalf to her, there's only so much I can do. And in this case, they weren't joint accounts, and there's only so much I could do. And she was forced to petition the court for an emergency order of guardianship. Anytime you petition the court on an emergency basis, particularly in matters of this, the cost goes up for a myriad of reasons, but most of all, from an attorney standpoint. That was a $50 document. She was eventually granted the emergency order of guardianship, and all's well that end well. My client made a 90% recovery, has a few small things from it. But just as a warning, here in the state of Kentucky, that emergency order of guardianship cost my client $14,000, and it's a $50 document. So if you don't think that these things are important, I'm just here to tell you that that changed my view drastically. Because instead of her just being able to handle and do that, she had the added stress of having to do that. And so many of you that don't honestly just kind of, toughen up, I don't know the lack of a better term, and start executing these things, that same thing, should you depart this world, is even more. And I witnessed that through walking both my mother-in-law when her husband passed away, a little bit through that process. And then I've just been through the process a couple of times with family members helping. And it's not easy, particularly when you're grieving. So general power of attorney, we've got to get one, folks, for both you and your spouse. It's very important to me. Okay, so moving on. I won't give you a story on every one of them, but that one always resonates big with me. So number two, a healthcare power of attorney. So this is where you appoint someone to make healthcare decisions for you when you're unable. It also acts as a HIPAA authorization, meaning that if you're unconscious, then a loved one has the authorization to get medical records to transfer from one person to another, authorizes hospitals to release those kind of things so you can get more effective and better treatment. Again, healthcare power of attorney, part of it. An advanced healthcare directive. So this is where, it goes to kind of a next level. If you have a terminal, incurable, irreversible condition that can result within death of 6 months, you can give a healthcare directive, which gives a proxy to carry out end-of-life decisions that you wish. And so, in other words, that directive, if I walk out and get hit by the beer truck, as my boss likes to say, then I have one of these that basically says if 2 out of 3, physicians are in full agreement that I am clinically brain dead, it's my wish to harvest my organs that are able to, and for them to pull the plug on my directive. And then that way my wife, or heaven forbid, my kids ever have to make that decision. The other conditions that qualify is a persistently unconscious person, so someone in a coma, end-stage condition caused by injury, disease, illness. Most, that can come into play in terminal illnesses that are long or even sudden, but end-stage can also be as a result of like a car accident. And again, you can give HIPAA authorization in order to share those kind of things, or even make those as well. And then here goes kind of to what I was saying, where you want either a non-resuscitation order or those kind of things, no life-sustaining treatment, but administer. These come into play, especially if hospice becomes involved as well. Particularly these last things. But again, advanced healthcare directive, very important part of your piece. Okay, on to different and other things. So beneficiary designations. This is something that everybody on this call has been exposed to one way or another. It's a pet peeve of mine. I've seen a few examples, and I've read about even more that honestly are just, they're kind of, for lack of a better word, they're kind of terrifying to me. Here's one thing you got to understand in the state of Kentucky, and I know there's some people on this call from Florida. I think we have a couple in Ohio and Kansas. Don't forget you, Eric, and some other places around. But it's important to understand what your state laws are. But in the state of Kentucky, I can tell you that beneficiaries supersede wills. So that means if you have a will and you have your intention set out on the will, but your beneficiary does not match up with that in the state of Kentucky, whoever's name is on there is who's going to get it. So when life events happen, divorce, spousal death, death of the beneficiary, maybe you just changed your mind who the beneficiary is, whatever the life event that's causing you to do that, I can't state it enough. It's really important that we keep those at the forefront of things that we have to change. And it's not just on your 401k. It's not just on your IRAs. It can be on, payable on deaths for brokerage accounts. It can be, non-joint accounts that have transfer on deaths. All those are forms of beneficiaries. And life insurance is the simplest one. If you do not have a beneficiary filled out, it will go to number one, if you do have a will but no beneficiaries, it will go to the directive based on the will in most cases. If you don't, then the legislature, based on the laws that they have passed, and the probate judge will be nice enough to do that for you based on the laws of which your state governs. Again, for most people, or many people, a retirement plan or retirement, account is some of your largest assets. Don't forget it. If you get divorced, don't be so bitter on the thing that you forget. I had a story where I was doing a joint education with a gentleman from One America, which is a big retirement company that some of you might be involved with. And he told a really good story about his brother-in-law. And it wasn't a funny story necessarily, but it was, and I don't know if it was true, but it convinced me. And he basically said that he had a brother-in-law that had been married 4 times. And number 4 was the same as number 2. So he remarried the person he married the second time. He got in a catastrophic accident and passed away. And number 1, he had changed, but he had not gone back and changed number 3, which is the least person. Actually, one did get one small account, he said, but number 3 got most of his money despite him being married again to number 4, and number 3 got the bulk of his assets, even though he was married. So again, not a funny story. He told it in an entertaining way anyway, but something to be cautious and aware of. I would also say, we'll talk about trust beneficiaries. I would be, it's very rare that you would ever have the need to name a trust as the beneficiary. There are some good reasons for it though. And that's something that we would definitely lean on an estate attorney's advice for. Out of my 45 biggest clients, I have one that has done that, to skip a generation, to go to grandkids, to build in some rules in terms of that. But regardless if it's an IRA, if it's a 401k, 403b, those are qualified retirement plans, and those are the most protected of any of the investment vehicles from a liability standpoint. It's pretty much impossible for someone to sue you or sue liability and break that qualified account veil of protection. So very, very important on that. Be aware of complicated rules. If it's not done properly, income tax consequences could result if you don't have your beneficiaries done correctly. Do your beneficiaries, people. It's very important. No will. So, what's the big deal? Or what happens? Well, again, we've covered it. It means the state law decides who gets your assets, who's the guardian of your kids, and who is the personal representative of your estate. The judge picks that too, by the way. It might be, might be your cousin, or it might be anybody. It doesn't have to be the next closest person to you, and the judges will pick that. The will. So what's it do? So a will is an instrument that directs how your assets are to be distributed, and how your debts, your taxes, and expenses will be paid after death as well. Wills have executors. It's also known as a personal representative. Executors you will pick as part of the will most of the time. The will does lots of the things that we've talked about that you want to have say-so in your life. So, guardianship for minors, benefit, if you have beneficiaries that are, that you want to make sure it's matched up or different, it will give it to those people. Its wills are very good for inventorying family heirlooms and leaving those accordingly as well with an exhibit list. For people who have minor or incapacitated or special needs, Honestly, it's one of the most important reasons for having a plan as well. Okay, so let's talk about trust for just a second. First of all, there's a couple of myths that I want to throw out the window to start with. I think there's a misconception amongst most people that I've talked to over time that think that trust planning is just for wealthy or just in certain situations or for maybe special needs or for, you know, some special circumstances or only for wealthy people. And let's just get that off the table that that's not true. If you want to break it down to its simplest term of what a trust does, a trust passes one asset, whatever that asset is, it passes one asset from one person to another in the most efficient way possible. First, well, what makes it efficient? Well, it's the only instrument that in which your assets bypass the probate court. So in other words, if you have assets and trust, those assets are trusted, let's call it, let's just say you have a stock account, a brokerage account, and it is, you know, Hunter Nighbert Revocable Trust, or whatever it's named, or Hunter Nighbert, you know, Revocable Living Trust, or however the attorney names it. They name it all kinds of different ways. First of all, it doesn't preclude me from doing anything with assets inside there. It doesn't make it, I can change who it wants to go to. I can spend it all before I die if I want to. So having a trust of a revocable nature does not preclude you from making any decisions. But what it does do is it takes that asset and it skips probate. And so from that standpoint, a trustee, you know, if something would happen and I have a taxable account or my house, which is in a trust, I would take, you know, my trustee would take the trust papers that involve those assets, would put them on the judge's desk. The judge would say, well, give me some time to review this. When he reviews them, as long as they're in good order and, you know, and legal and bona fide, then what the judge will do is give you back the trust papers and say, good luck, because those do not become part of that decision-making paradigm for him any longer. So that, in its simplest terms, it transfers one asset from one in the most efficient way possible by bypassing probate. Excuse me, long day. It's really good for providing succession management. So if you have a family member or trustees that you really, you know, kind of trust to kind of do the right things and would do them in the spirit of which they think you would want to, then great, they're great. They're very flexible on the revocable trust. You know, the protections are not so much for you. So, you know, it doesn't affect your income taxes. You don't bypass taxes with a revocable trust. You don't bypass Medicaid recapture with a revocable trust. But there are some advantages in terms of how you pass that. And then once you pass away and your trust goes into effect to them, then there's some rules that do, from a liability standpoint, protect that asset going forward in certain ways. So usually what I see in revocable trust is a wife has a trust and the husband has a trust. And if the husband dies first, his trust pours into hers or her trust pours into his. When they both die, they both pour into a trust for the kids. The trust has rules. And at that point in time, there's liability protections, meaning that those don't become property for marital and other things for that next generation. An example. We put our house in a trust about 6 or 7 years ago, and it was, you know, we had been paying on it pretty good. We have a good amount of equity in our house, and so my wife and I work extremely hard, and when we started working on these things, I basically said, listen, okay, here's the deal. We're gonna put this in a trust, and it's for the kids. The kids are the beneficiaries of our trust. I'll tell you, I don't mind. So when I die, it doesn't preclude my wife from doing anything to our house. She can sell it. The assets of the proceeds will stay trusted. She can buy a new one under the trust. She can do, anything she wants to. She can borrow against it. She can downsize, all the things and decisions she wants to. I joked around with her and I told her, I said, listen, when I die, I give you full permission to finally go meet the man of your dreams. And once that occurs, I wish you nothing but love and happiness, forever. And I'll see you on the other side. But you should know that the trust that we've created for our children is not an asset that your new man or husband, should you get remarried, can ever lay claim to. Nor can it be laid claim to on marital property for each one of my kids once they become married. So once it's trusted and it goes down that line, it is no longer marital property for any of those people. Her and I have been working in a partnership. We've been married 20 years at the end of this month. Pretty unbelievable. We're very good in terms of working together, and I would want nothing but the happiest for my wife. But let's be honest, I've not worked my fingers to the bone for the next guy to come and lay his hands on it. So another example of how kind of trust can do that. Real quick, the protection against long-term Medicaid recapture. So what that means, just so you know, is that should you ever think you're going to have a need for Medicaid, say you have to go into a nursing home and you're there for a long time. The way Medicaid works is that they are able to go back on assets that you have and recapture what they can from those assets. So if you have a house, they can levy or put a lien against your house until it's sold, and then they get paid back money that they're owed. There are trusts, absolutely there are trusts that will help you avoid that. There is a look back period of 5 years on Medicaid recapture. So it's important, if that's something that's important to you in planning for some of those things, to reach out to a qualified attorney to get those answers. A lot of it gets down in the weeds. I've had a couple of clients that have done that, have really come up with some really good plans. In particular, one really good friend of mine has been a long-term care person for his father, who's been living together and kind of put his life on hold for a long time. And so there's a lot of things that you can do to kind of protect the asset going forward. Irrevocable trust. Let's just touch on these things real quick and we'll wrap up. But irrevocable trust is a type of trust where its terms can't be modified, amended, or terminated without permission of the grantor's named beneficiary or beneficiaries. So once the trust is done, it is very difficult by nature to change. But because it's so difficult, it does offer tax shelter benefits that revocable trusts do not. It also completely removes things should you have an issue with the estate tax threshold. You'll be hearing more about that probably in the press over the course of the year. Right now, the estate tax threshold is 11.5 million per person. So basically almost $23 million for a married couple. So as long as you don't have more than $23 million, it's exempt and you don't have to worry about paying estate tax. There's lots of changes that are being thrown out there. Some people say we'll go back to 2006 levels, which is about $3.5 million per person. I tend to think that it'll be somewhere in between those numbers. Why I don't have any insight. It's not a Republican or a Democrat thing. It's not as if Republicans want it to be 23 and the Democrats don't. I have no opinion on that matter. It's just the fact that they're going to try to start recapturing more money because the government needs it regardless of who's in power. And I don't think it'll go down super low, but it could. So it's something to pay attention to, and trust planning can help you take things completely out of your estate from a tax standpoint on an estate end to avoid those things. So what are revocable trust, or who I should say, a revocable trust good for? Well, it's for what I just said. If you're going to be over and above the exemption, so if that exemption does change and goes down to $3.5 million, I know there are several people on this call that meet that need and meet that definition. So it's a lot of money, but at the same time, if those things changes, it's important to stay mindful, unless you're okay with with your heirs paying 40-45% of what you've already earned in the form of estate taxes, and that's due within 9 months. There's no exceptions, by the way. It doesn't matter. It doesn't matter if you can't sell your property. It's cash on a barrel with their handout. That's the way it works. If you want to become more eligible for government programs, and irrevocable trust is really good for that, because it completely actually takes the asset away from you, control and everything. So you can become eligible for Medicaid and other things a little bit easier. This is a big one. It protects your assets from creditors. So if you've got debt and they want to come after it, they can't come after the irrevocable trust, because they're not going to get it. Possibly the biggest, I wanted to cover a couple of negatives so you all understand on irrevocable trust. And again, your qualified local estate attorney, which are the good guys, by the way, that they'll help you. But possibly the biggest negative that I can think of irrevocable trust is that don't forget that you lose control of property or whatever asset is transferred into the irrevocable trust. You no longer have say-so. It is not yours. The trust determines it by the rules from there on. So it's not as if you can just get it back. You might be able to get help with beneficiaries from that, but it's very difficult from what I understand. Another one is, let's say you made your youngest child the beneficiary of the irrevocable trust. And let's say they just did something almost unforgivable and they ticked you off. Well, sorry. I mean, he's permanently your beneficiary. Can't change it. There are trust companies that can help execute those in terms of the rules that are put in place for them. And then estate tax exemptions have increased. So 23 million, if they stay in or close to that, it doesn't affect most people. It's those are ones off the top of the head that are the biggest negatives for the irrevocables. I will say with this, there are some really good irrevocable types that can do very good for you, provide income, and charitable trusts are very good. I'm a fan of those. So there's a purpose for all of it. It's just whatever your specific need is. Another type of irrevocable trust that's really good are special needs trust. Oftentimes special needs people will have a higher risk at Medicaid of using Medicaid for insurance purposes. Let's say they're disabled at a young age permanently. And special needs trusts are really good. There's first party and third party. I'm not going to get in the weeds on that now, but if you have questions about special needs trusts, if you have a special needs child in your life, reach out to me and I can give you some examples of what I've seen and how that can benefit you, and the differences between a first person special needs trust and a third party, a first party and a third party special needs trust. But those are types of irrevocable trust. Third parties can be revoked, first parties cannot. So, those are good examples of trust that can help separate things, so Medicaid can have a limitation on what they can get on special needs situations. Okay, so lastly, we're gonna go through a couple things. I'm gonna let you go. Sorry, it's long-winded, but it's important stuff, and I want to get through these things. What is probate? Probate's the legal process in which a deceased person's estate properly is distributed to their heirs and their designated beneficiaries as well, and any debt to creditors that are paid off. So in generally, probate is property distributed accordingly to your or the decedent's last will and testament, if there is one, or according to the state laws if one does not exist. What is the process? First, I want to tell you the length of the process. I can't speak for all the states on the call. I've only had exposure to 2 of them, quite honestly, Kentucky, well, 3, Kentucky, Ohio, and Florida. But what I can tell you is Kentucky and Florida on average, it's a minimum of 6 months. You look it up, it's a minimum of 6 months in most places. But Kentucky, the average is closer to 9, according to my attorney friends. First, you have to, petition to have the will and the executor appointed. Those are, usually the first step process. And there's an inventory that has to be taken of all the assets. You have to give notices to the creditors, heirs, and all the beneficiaries that, someone has passed away and that they have been named as a beneficiary or heir or creditor. Pay income and estate taxes. You will have to file a state return in the year where your executor will, and the year that you have passed away. Pay off any debts, any debts associated with it first, ideally. And you got to be careful because debts can be inherited too. So even more reason to have a state plan really looked into if that could be a possible case. I've seen some sad stuff on that one, only on one occasion, but it was heartbreaking. Make the distributions to the beneficiaries. You're in charge of calling the custodian or the record keeper and getting that money over as an inherited IRA to the proper beneficiaries. And then, you make final accounts and close the estates. What goes through probate? So basically, whatever assets are purely held individually at death. Examples of that would be, any real property, and that can be, it doesn't have to be like house property. It can be physical gold, jewelry, those kind of things. Interest in entities such as LLCs. Those are really the main ones. Mineral interest is on there in case some of you own coal or have water rights where you live, or those kind of things. Those can be a part of it. There are no water rights individually in Kentucky. There are mineral rights, obviously, with coal and natural gas and some of those things. Life insurance, if you do not have a beneficiary properly filled out, it will go through the probate process as well, as long with any non-named transfer on deaths or payable on death accounts as well. What are non-probate assets? So jointly held with rights of survivorship. If you have a joint checking account, a joint investment account, those kind of things, it is not necessary for those to travel or to pass through the probate process. Assets with a beneficiary that has passed away, maybe, that has not been changed, and that goes for all the things below. Life insurance estates, and then assets owned by trust are non-probate assets as well. So before I hit stop on here, just in conclusion, if you don't have a state plan, I think we beat a dead horse here today, but don't delay. If you have no idea where to start, reach out. That's what I'm here for. It doesn't matter what state you're in. I can get you in a network and help if you don't have the money in for some of these processes. And that brings me to the next thing. We'll talk about that in just a second. But if you have a will or a power of attorney and all the documents and they're more than 6 years old, I would encourage you to get those reviewed at some point in time. You're better off than not having it. But the reason 6 years stands out, there was a lot of modernization within will language and those kind of things within the last 7 years. So if it's more than 6 years old, I tell people to get it reviewed. And that wasn't just Kentucky. That was kind of across the nation. There was a push on individual states that had language that made it honestly just broadened the language and made things a little bit more favorable within the language of the will. So if you don't have those, then look at it. So that brings me to the last thing, and I'm going to stop sharing really quick and bring it over here. But that brings me to that. So let's talk about cost of these things. One thing I didn't get into in the presentation was, that probate does carry a cost, and the cost is a percentage, and every state is different, but it's a percentage of the assets in terms of the value of them that have to pass through the probate process. So that being said, if you're passing most of your stuff through there, you could probably count on having a couple of thousand minimum, depending on what your situation is. And, so that's going to be spent on the backside. What I can tell you is meeting with an estate attorney will generally save that process and that bill up front. For simple wills and wills and power of attorneys type things, I mean, it depends on where you're at. Everybody charges a little bit different, but it's not unreasonable for you to find it in $500, $550 and under for the whole thing. There are places I know where you can do it cheaper. I can even give you direction of places to go and do it on your own, for the most cost effective possible. An example is, it's going to sound cheesy, but you all probably heard commercials at some point in time for a service called LegalZoom.com. I'm not advocating for LegalZoom, but you can do wills and power of attorneys on LegalZoom. They have a help desk. You can call in and they help you give instruction to make sure they're state specific. I've gone through the process up to the point before you have to pay for it in order to get it. It's fill in the blank kind of things. And if you have a real question, then you call and talk to a paralegal or an actual attorney, and it's included. There are other encompassing services that kind of do the same thing, and you actually get access to an attorney from like a network kind of thing. We're exploring a little bit more of that on our end right now, of maybe using some of those for simpler type things. For trust, there's no doubt you need to find a qualified estate attorney, make an appointment, because it's gonna take you a couple of times. There's gonna be some things to consider. Trust planning, I've seen it as much, I'll be honest with you, I've seen it as much as $30,000. Most people pay about $2,000 to $2,500 for simple A/B trust planning, like I was talking before. Special needs and some of that Medicaid recapture type trust, in my experience, $6,800 to $8,500, $10,000, depending on the complexity of it. But the nice thing about estate attorneys is that, to get those things reviewed. So if you had a will that was 6 years old, just reach out. Most people will review those for free, and they'll give you their opinion whether you think you should update it or not. And that doesn't cost you anything in terms of just providing it to them and getting an opinion. And then you can listen to what they have to say if it should or shouldn't. But in terms of the specifics of the trust, it's very important that you contact one. If you don't know where to start, reach out, and I'll do my best to help you. Obviously I don't have, one of a gentleman that's on the call that I've talked to many times, Eric, over the years. Eric lives in Kansas. I don't, other than we have a trust service company in-house that we use is based out of Kansas, I would pick up the phone and have to call them. But what happens is most attorneys, so the one I deal with is licensed in Florida. He's got a master's in taxation from taxation law from Florida, and a law degree from the University of Kentucky. He is here, Kentucky, Indiana, and Florida. And I know 2 or 3 that have maybe surrounding states. But if they're not licensed in a spot, he is in part of a network of qualified people and could recommend someone to us. So that being said, no matter where you live, feel free to reach out. If you want a personal opinion on what you think you should do in terms of that, not everybody has to have trust. I'm not saying that. I would think most attorneys, if you have a decent amount of assets, and a decent amount could be you know, depending on what the makeup of the assets are. There are some triggers that regardless of how many assets you have, people would recommend it. If you own property out of state from where you live, I've never seen a state attorney not say that that's a triggering event where you should have a trust. And you put that in there, it bypasses the probate in that state, because your probate isn't, you know, if you have a house in Kentucky and a house in Florida and you live in Kentucky, that house in Florida goes through Florida probate, doesn't go through Kentucky. A trust alleviates that. Very important for lots of reasons, because if you have to get an attorney, they know you're out of town, the price goes up. I've seen some, particularly not in Florida, but I've seen some in Alabama with some clients that, you know, were inherited 1/4 of a piece of property, and, you know, the bill for just representing them through probate, it was ridiculous. So yeah, that's all I really have. Is there any questions? I don't see any that were typed in the chats. I will, you know, allow you guys to talk if you want to, and if you're going to be completely silent, then I understand too. Don't raise your hands all at once, people. Listen, I get it. It's a lot of information. It's overwhelming, and sometimes questions are, you know, they're best on these types of subjects met in private. So I appreciate that, Eric. Thank you for that. Yeah. So listen, again, don't be intimidated by the process. And it's a process that doesn't end. You know, it's like financial planning. When you make a financial plan, folks, it's not like you do it one time. Circumstances change. And estate planning is especially that way, because perhaps, you know, a loved one that you were planning on leaving some of this stuff to passes away first. So this is a moving thing. Plans are living things. They're not a one and done type situation. So always keep that in mind as your life changes, as life events happen, that it's important to update all these things. Beneficiaries at its basics, you know, wills and estates, trusts, beneficiaries, all those things. Any other things? Any other things? Well, reach out. You all have got, anybody? No. Reach out to my email if you need it, my Calendly link. You all get the emails from me. You can reply and it actually will come back to me. So honestly, reach out if you have any needs or concerns. I will be out of town for the next few days. I can return emails, but won't be having any meetings until we get back. So other than that, I really appreciate you all taking the time to go through this information with us. I hope it's beneficial. Feel free to share it with friends or loved ones if you want to. We will send the link out. You all get it individually to go back and refer to. And I appreciate your time. And you all, it is well, on my watch, it is 4:59 Eastern Standard Time. So just a hair bit under an hour. So we're going to call it a day. You all have a wonderful Tuesday and a blessed week. And I will talk to you guys or see you all real soon. See ya.